Okay, you may start.
Welcome to the League of Women Voters Tacoma-Pierce County Candidate Forum for Pierce County Superior Court, Department Number 4. I'm Lydia Zapeta, the moderator, and on behalf of the League of Women Voters of Tacoma-Pierce County and our community sponsors, I welcome everyone to this virtual forum. Before we start, I wish to acknowledge that today we meet on the ancestral lands of the Puyallup tribe, surrounded by the traditional waters of the Coast Salish peoples, in the shadow of Mount Tahoma. May we make intentional efforts to create inclusive and respectful partnerships that honor Indigenous cultures, histories, identities, and socio-political realities. The League of Women Voters is a nonpartisan organization whose mission for the past 100 years has been to empower informed and active participation of citizens in government. Candidate forums are one of the many ways that we do this. Anyone who's 16 years or older can join the League of Women Voters. If you're interested in doing so, you can go to our website and join. It's www.tacoma-piercelwv.org. Today's forum is for Pierce County Superior Court, Department Number 4, Position Judge Department Number 4. The candidates are Brady J. Horenstein and Brian Chuskoff. The general election is on November 3rd, and all of you should have received your ballots. The forum is being recorded, and if you want to see this forum again or any other of our forums that we've done, please go to our website. It's www.tacoma-piercelwv.org/2020elections.html. Live audience participants can send questions. They can be texted to, and hopefully you can see this, 253-948-6029. That's 253-948-6029. Questions must be to both candidates and may be reworded or consolidated. Our timekeeper today is Terry Baker from the League of Women Voters Tacoma-Pierce County. She will be holding up cards to let you know when you have 30 seconds remaining and then 15 seconds remaining and when it is time to stop. When you see the stop card, you may finish a short sentence. Please stay on gallery view so that you can see me and the timekeeper, Terry Baker. Please do not talk unless it's your turn, and please mute yourself when it's not your turn to speak. The audience is on mute and cannot use the chat function. Just a reminder that civility is expected. Please stick to the issues and refrain from any personal attacks. Each candidate has up to 2 minutes for an opening statement. After that, the order of the questions will rotate and each candidate will be asked the same question. At the end, each candidate will have 1 minute for a closing statement. So the order of the opening 2-minute statements is ballot order, and we'll start with Brady J. Horenstein.
All right. Well, good evening. Thanks, Lydia. Thank you to the members of the League of Women Voters, Judge Shishkoff, and all of you watching at home, and those of you who will watch this later, since it's going to be recorded and available. It's definitely interesting times too. This is the first time I'm running for election for anything, and this has been an interesting year, I think, for all of us. We can certainly say that. So briefly, I just wanted to tell you a little bit about myself, tell you the things I'm for, and tell you why I'm running. And I look forward to the discussion tonight. I decided to run because I think that voters in Pierce County should have a choice about who their Superior Court judges are. The way we elect judges in our state and in our county is kind of interesting in that when a judge is first elected, oftentimes you'll never see them on the ballot again because they are rarely, if ever, challenged. And since we do have elected judges in our state, I thought it would be a good time in light of everything that's going on. So I know people are crying out for change. They want their voices heard now more than ever. We can watch the news every night and certainly see that and see what's going on across our country and in our own community. And so as a newer resident to Pierce County, I grew up down in Vancouver, Washington, and moved up here several years ago. As a new resident, someone who didn't have the chance to vote for Judge Shishkoff back in 1990, 1994, 1996, I wanted to give voters a chance to look at these races, think more about these down ballot races like the Superior Court race, and make a choice for who they want to be their judge today. And I know Judge Shishkoff has talked a lot about the things that I'm not, but I wanted to tell you about the things that I'm for. I've been I've worked as a legislative liaison for the state courts. I've worked for agencies. I've worked as an attorney for a number of years, and I have a very different skill set, different experience that I've developed over a number of years that I think will bring a lot of value and diversity of experiences to the court that I'm really excited to talk about tonight. So again, thank you for having me, and I look forward to a good discussion.
Thank you. Brian Shishkoff.
Yes, thank you very much for sponsoring this forum. It's an opportunity to reach out to voters, and I certainly applaud the efforts of the League of Women Voters, and it's a venerable institution. It's been doing this for so many years now. Indeed, I'm Brian Shishkoff, and I'm seeking re-election as a Pierce County Superior Court judge. It's a job I love and one I've done well for nearly 24 years. As you decide who to hire, I ask you to compare candidates and ask yourself, who will do a better job? I believe selecting a good candidate for any job begins with considering whether the candidate likes the work. Trials are my life's work. I have found it rewarding to help people through difficult times. I've been an excellent judge and lawyer for more than 40 years. Mr. Hornstein does not have a conventional legal background. He has never picked a jury. He's never examined a witness. He has never tried a case. And I think it's important that we have that in mind, because as we decide who to pick, and given the nature of this job, which is more about trials than anything else, we want to make sure that that whoever is in front of the judge has a good judge, because the decisions of a trial court are too important to leave to the inexperienced. As the News Tribune said in endorsing me last week, the absence of trial work on Mr. Hornstein's resume is glaring. And that's likely why the Pierce County Democrat Endorsement Committee described me as an able administrator who is better qualified for this trial court position as a sitting judge with a strong record of performance. More than about any other job, this job is about justice. It is about understanding the human condition, understanding the law, and keeping in mind that the court's decisions have enduring consequences for people. So when you're in difficulty, you want a good judge, one who will treat you fairly and competently. And to do that, experience matters. So I think, and I hope that tonight we have an opportunity to discuss some of these things in more detail, and hopefully I'll be persuasive. Thank you.
Thank you. Thank you both. Now we come to the questions. Each candidate will get up to 90 seconds to answer the question. Since we have just an hour, including opening and closing, brevity is appreciated, so that we can ask as many questions as possible. And again, live audience members can text their questions to 253-948-6029. That's 253-948-6029. The candidate order will rotate for each question. So for the first question, we'll start with Brian Shishkoff and then Brady Hornstein. Okay, first question. Please explain to the audience, what is the role of Pierce County Superior Court in the judicial system, and what is your vision of how it benefits the community? 90 seconds, please. Brian.
Well, of course, the Superior Court was created by the Washington State Constitution in 1889. It is the trial court for the state of Washington. And so it has a jurisdiction, a legal authority to handle legal disputes involving any kind of civil matter and any kind of criminal matter in which the criminal penalty is more than a year in jail. And of course, and so that's a felony criminal matter. So the Superior Court plays an integral role in establishing order and solving disputes within the community. So we're handling divorce matters, boundary line disputes, personal injury cases, medical malpractice, in addition to the felony criminal crimes that you're more often, I would think of us in terms of doing work, and for which we're so more frequently in the newspaper. But it starts in the trial court, and then it's the appellate courts that review our decisions. So justice occurs first there. And so the most important aspect of what any one of us does is conducting the trial. And conducting the trial is, of course, a complicated matter and requires a certain amount of experience, not just in the human condition, but certainly in the law. And one who is a lawyer for a very short period of time, who simply wants to try a case in court, needs a lot of years of doing that before they feel like they can reasonably conduct a trial, as a judge does. A lot of times a lawyer will ask you what to do. What's the procedural process here? And you need to be able to provide an answer for them. And you're the one sitting there on the spot with no one else to help you. You're on an island in that sense.
Thank you. Mr. Horenstein.
Thank you. I think courts, trial courts, they're in every county in our state primarily, and they are where people go when they need help. And most people do not end up at the Supreme Court or the Court of Appeals because of cost and just the funnel that exists. So the Superior Court and even the district and municipal courts in our state is really where people who actually have to go to court for a criminal or civil matter tend to find themselves. So most people, I think, have the good fortune of never having to go to court. They're able to avoid criminal trouble. They're able to avoid trouble, and they're also able to avoid disputes with neighbors or colleagues or a divorce. But for those of you that have been to court or will go to court in your lifetime, it should be accessible, friendly, and as customer service friendly as possible, despite the challenges that people are facing. So the trial courts is really like kind of the front door, kind of the ground floor where people go in and face their legal troubles. And I think that's why it's so important that we create a system that's more modern and effective, especially now with COVID. People are going to need the courts for all sorts of reasons, as they have before, but even more, they're going to need courts to resolve their disputes in unique ways. Whether you need a protection order, whether a child or a young adult child is dealing with mental health issues, whether you're dealing with a family law matter, or divorce, or child custody issues, or a criminal matter and you're a victim of a crime. The courts are where everyone goes to resolve their disputes. And it's very important in our criminal justice system that the courts function and the trial courts function appropriately and effectively so that everybody can seek justice.
Thank you. The next question is about the justice gap. The justice gap is the gap between legal need and resolution of that need. A 2017 report found that 71% of low-income households experienced at least one civil legal problem in the last year, such as housing, disability access, or veterans benefits, and that 86% of the civil legal problems reported by low-income Americans received inadequate or no legal help. How would you promote access to justice to close the justice gap? Mr. Horenstein.
Well, absolutely. I absolutely agree with you 100% with the statement you made. Our legal system is it's cost prohibitive to utilize the system. Attorneys, for those of us who have practiced and had to track hours for billings, we know that it's incredibly expensive. And oftentimes those without resources are simply unable to even begin a case or begin to hire an attorney because the cost, even the amount they have to pay up front to visit with an attorney is so expensive, which is why civil legal aid is so fundamentally important. And in our state, when I worked for the state Office of the Courts, Administrative Office of the Courts, I worked closely with partners at the Office of Civil Legal Aid. And that is a high priority, I think, throughout the judicial community, as well as just our legal community in general, is we need additional funding for civil legal aid so that individuals who cannot afford an attorney have access to legal resources and legal assistance. And there is a huge gap. And the number of people facing legal jeopardy or legal challenges, especially right now, due to COVID-19 is through the roof. It's absolutely significant. And these have the potential to really overwhelm individuals who aren't familiar with the system. So I will do everything I can as a judge to support those efforts to increase funding for civil legal aid, participate in our community at community events to raise more awareness about the gap and the need for civil legal aid, and even speak with legislators and others and lawmakers about increasing funding for that. I am wholeheartedly committed to that effort, and I look forward to doing that if I'm elected.
Thank you. Mr. Cheshkov.
It is true that funding for the courts has always been difficult, and with the way the Constitution of the state of Washington sets this up, almost all the expense for that is paid for by county government. And we've been pretty fortunate that our county government has been pretty willing to work with us on things over the years. But where civil legal aid is going to have to come from really is funding from the state government. And so far, the state has not been particularly interested in doing that. So there's a number of things that we can do, at least at our level, to try to be as practical about this as possible. So we have seen a large increase in the number of people who represent themselves. So one of the things we try to do to help people do that is we try to formulate forms that are more commonsensical, that are more common language kind of forms that people can then represent themselves. And we have developed processes by which we can monitor how they're doing. So for instance, I was part of a system which set up a mandatory court review hearing. So when folks come into court, we have a way to circle back with them and make sure that they're in fact processing their case. Because when they come into court, they face a maze of legal procedures. the forms, the law that they don't necessarily understand. So there's a number of things that the local court can do to give them training, access to videos on our internet, our website. And as I say, circle back with them and find out what's going on and what are the log jams, if you will, in them getting a resolution of their court, of their case. And that's been a very successful program for us.
Thank you. Next question. This is a yes or no question, and then there'll be a follow-up. So first of all, I'd just like to get a yes or no. Do Black Lives Matter? Yes or no? Brian Shishkoff.
Sure. Yes.
Mr. Hornstein.
Yes, absolutely.
Okay, so following up, if yes, how will your courtroom demonstrate this practice? And we'll start with Brian Shishkoff.
Well, one of the things I've found is that if we make court procedures fair for everyone, this benefits people of color disproportionately, because they've been so often a part of the product of the justice system. So trying to improve court procedures is particularly important. So one of the things that Mr. Hornstein said in his opening remark, it has to do with managing the court in a modern way. I was selected to go back to Denver to a workshop of the National Center for State Courts. They were doing a study on effective criminal case management. I was selected to go back to that because I've been such an integral part and a leader on our court in improving criminal case management. The National Center for State Courts identified Pierce County as one of the 7 best courts operating in the nation in terms of efficiency for that. That's important for a number of reasons. One, if someone's been charged with a crime, they're often incarcerated for long periods of time before their case can get heard. We want to minimize that period of time. 2, to the extent that a case gets decided late in time, then memories of fade, evidence can get lost, and one has less confidence in the validity of the outcome. These are all things that are important to people of color because they want a fair system most of all. And so we have taken enormous steps to do that. We've also introduced unconscious bias training in our juror video trainings for them, and we've improved language translation of forms into various languages. I was the leader on that, so we translated a number of forms into Spanish, Vietnamese, Korean, Russian that had never been done before. Those other languages had never been done before.
Thank you. Mr. Horenstein, how will your court put into practice, demonstrate in practice that Black Lives Matter?
Absolutely. And I think this is one of the most important issues and one of the big reasons why I decided to run and give voters an opportunity to think about who should be their judge. I was really impressed and very proud of the Supreme Court for earlier this year. They released a letter basically acknowledging the role that the courts have played in a number of ways in creating systemic racism around our court system and in society, and that all judges and all people who are part of the system need to be spend extra time and pay extra attention to addressing those historical wrongs. So as someone, I firmly believe in that and will try to do that every way possible as a judicial officer. And I think that's a personal journey, and it requires me to listen and learn and be as engaged as possible. And that means trainings and working with colleagues and being out in the community, doing everything I possibly can to address these issues. And I think, you know, one of the important roles for a judge, aside from hearing cases and the kind of the typical role of a judge, is being out in the community. And that means meeting with young people, educating young people, listening to young people, and making sure that people from a very young age have believe in the system, believe in that the judicial system can work for them, and believe that it's fair. I think that's fundamental to our democracy. The rule of law is very important. So as a judge, I'll do everything I can for making sure that I'm addressing my own implicit biases and my own training needs and my own gaps there, but also being out in the community and doing as much as I can to learn and educate about our court system.
Thank you. Next question. What measures should be tracked to ensure that people of color are treated equitably by law enforcement and in the county judicial system? 90 seconds, Mr. Horenstein.
Sure, and actually, you know, that's the one thing when I came to the courts, I actually was at the Department of Licensing. I have other state agency experience prior to working at the state courts, is the executive agencies are very good at performance management and performance measurement, and doing a really great job at analyzing statistics on a regular basis to evaluate performance and evaluate outcomes. And I think the court system, the court as a branch, is not nearly as good at that, and it needs to improve in that significantly from a data management, data tracking, and just the tools in place to make sure that we actually know what's going on and we can monitor those things. So that's a systemic issue. I think that's a technological issue. I think Pierce County is in a better position than a number of counties and other judicial systems around the country, but it's work that needs to continue. So I definitely want to address that as a judge, but also I think you can start to look and just by being out in the community, I'm going to go back to that, by connecting with our civic leaders and by reaching out to them on a regular basis and getting a sense from them and getting feedback from them about how they think things are going. So, and how they think the relationships are improving and whether people feel more confidence in the system. We can look at outcomes. There are a number of studies and a number of groups like the Minority and Justice Commission and other outside organizations outside of the judiciary that are always looking at these issues. So we can trust them to continue to do that great work, and also as judicial officers doing everything we can inside the court system and through the court proceedings to make sure that good data is available and that we're doing everything we can to be out in the community and connect with individuals and connect with these civic groups and understand what's going on.
Thank you. Mr. Cheshkov, what measures should be tracked to ensure that people of color are treated equitably by law enforcement and the county judicial system?
Well, one of the things that's been important and part of that our court has been trying to do, which I think will have great practical implications. I mean, there's been a lot of talk and not a lot of action, and there's been a lot of aspirational discussion without any real concrete quality to it. And that's been, I think, frustrating for folks. One of the things that we've been doing for a while now is we've asked our court administrator to study our jury pool, the folks who comprise the juries, the people who come to court, and to see whether or not what we can do to try to improve the number of folks who are of different socioeconomic backgrounds, different racial backgrounds, to improve the diversity of the juries that we have. We think that there'll be a better confidence in the outcomes if the public has confidence that the juries are composed and comprised of folks who have a diverse background. And so we've done really a pioneering work in this for the state of Washington, and a lot of this information has been gathered, and there's been a lot, but it's now another issue of trying to bring this information to public attention so that the public becomes more attentive to this. But our information was provided to the Supreme Court at a symposium last year. They're very encouraged by what we're doing there, and I am too, because I think this is more than almost anything we can do. I think that would be a huge step in terms of proving the basic integrity of the system and the public perception of that.
Thank you. Law enforcement have access to professional interpreters by telephone 24/7, yet they rarely use this service. Just last week, a woman told me that her 10-year-old daughter was asked to interpret for her and the child's father in a non-emergency situation regarding domestic abuse. Please comment on the failure of law enforcement to use professional interpreters when interviewing non-English speakers and the implications for police reports and hence court proceedings. Mr. Cheshkov.
Well, I think that's regrettable, and I don't think it's necessary, although it is expensive, and it can be complicated because in any given year, our interpreter services folks might deal with as many as 80 different languages, also with people who are hearing impaired and so on. And so it's oftentimes difficult to find the right interpreter, especially in an emergent situation like a police call. But for lots of languages, Spanish obviously in particular, but some others too, some of the Asian languages such as Korean or Vietnamese, there are a number of people that provide interpreter services for that. The Pierce County Superior Court has been a leader in this. When King County was getting sued by the Obama Justice Department because they were not complying with interpreter standards, we were already there. It was one of the reasons why I was frustrated by my request from the Administrative Office of the Courts for improvement of standardization of translation of these forms in these other languages, that when we weren't getting any action from the state, I managed to get some money to get interpreters to translate these things for us. And they've been put up on our website. And so these are accessible to various folks. Now, that doesn't necessarily answer the police situation that you've discussed, but it provides a resource that they could tap into if they needed to, at least certainly during working hours. And there might be some ways by which we could expand that program and make those interpreters available to the police. Because I agree with you, it's entirely important to get it right, and we get it right from the beginning when the police are first investigating these things.
Mr. Horstein.
Sure, there are a few parts to this. I think there's both the civil rights aspect. I think there is a a federal mandate around civil rights, and I think people have a right to be able to come to court and access court services. And if that means if they speak a different language or they struggle with English, or that they should have access to resources and forms and translation services, and that should be readily available. And I think that's not only for courts. I work currently at the Department of Social and Health Services, and we spend significant time and effort and resources to make sure our services are accessible for people who speak different languages. That's just fundamental. And in our society, in our community, especially, like Judge Shishkoff mentioned, I mean, there are between 80, I've heard 80 as high as 140 different languages that are spoken in our region. And those are, those are people with real problems. So just for those of us who don't deal with this or haven't had to experience this personally, I mean, just imagine entering the courthouse, not being able to speak English, but you need a protection order. Or you're divorcing someone in a violent relationship, and you need access to these services, and you need access immediately. The inability to have translation services or interpreter services, or even with law enforcement, if they've come to your house to address a domestic violence issue, for example, we just need to change the culture. We need to continue to push on this until everything is translated and it's available. And I do think this is another opportunity where technology is going to help us a lot. We need to be willing to use new technology. Google is working on something that will literally just in real time translate language. So I think we need to continue to look at technological options as well, because there just aren't enough people and translators available currently to address this. So that's what I'd focus on.
Next question. Many victims and perpetrators have experienced severe trauma, such as being trafficked, sexual abuse or exploitation, child abuse, or incest. Trauma-informed justice recognizes the impact of trauma, does not re-traumatize, and empowers people. Explain how your courtroom would be trauma-informed. Mr. Horenstein.
Sure, absolutely. This is one of, I think, one of the most fundamental issues that the court system is trying to grapple with. And I'm very moved, and I certainly support those efforts. And when I was at the state courts and would attend judicial conferences and got the chance to listen in on sessions, there was a lot of effort going on around this. And I personally absolutely believe this. As working in a social service agency, I certainly understand that trauma can affect everyone, can affect someone's interactions with the system, and it can make things very uncomfortable, and it brings up a lot of challenges. So part of it is being educated, right? And as a judge, we, as assuming I'm elected, would face a lot of different issues coming at me right away. But I think this is one of those understanding and reading the research and going to as many trainings and virtual trainings as much to understand this issue as much as possible is really important. Because from what I know about it and what I understand about trauma is that things that are seemingly innocuous to me could be very triggering and very damaging to someone else. And that is just important awareness that we all need to have as we interact with each other. And no one should come to court and then walk away, feel re-traumatized or be re-traumatized or face that kind of treatment in court. So I certainly would go out of my way to create an inclusive environment in my courtroom, definitely address bad behavior by others, and certainly want to do everything possible to make sure I'm doing everything I can to create an environment where people feel safe and comfortable, while also recognizing the constitutional issues that sometimes we face in criminal matters that make some of these things challenging. But it's absolutely crucial that we make this an integral part of our work, and I'm fully committed to doing that as a judge.
Thank you. Mr. Cheshkov, how would you make your courtroom trauma-informed?
Well, the nature of a courtroom is sometimes an adversarial process, and it can be an emotional scene. You can imagine anybody, no matter who you are, even if you have kind of got it all together, but if you've been a rape victim and you have to come in a courtroom and everybody is treating you just as gently as possible, you can imagine how horrible that is to talk about your sexual activities in front of a room of strangers, where there's a court reporter writing it all down so that the Court of Appeals can look at this later, the Supreme Court can look at this later. And you're going to be cross-examined by a lawyer representing the defendant. That is just an intrinsically difficult situation. And in some ways, there's no way getting around that if you're going to have a trial to try to get at the truth. We can do some things to try to minimize that. We can certainly start, I suppose, by making sure that defense lawyers know that they have some limits as to what they might be able to do. But they've obviously got the right to cross-examine somebody. But it's also interesting to point out to them that alienating the jury is not going to necessarily help them in their cause either. We've used things like service animals, and then the prosecutor's office has had a dog for children, especially when they're children witnesses. And this has been a very good program. We had some difficulty with the county executive not wanting to let service animals into the building. We convinced her to change those things a few years ago, and that's been a useful thing. So there's a number of things. We try to, of course, certainly treat everybody with just respect as much respect as we can, as much dignity as we can. But these are difficult issues, and I'm not sure there's any absolute guarantee that somebody's not going to come in and get re-traumatized. Sadly, it's the nature of the beast, but we can do our best.
Thank you. Next question. Please comment about the impacts on the court system of criminalizing homelessness. How do you see the best way to address homelessness, Mr. Chushkov?
Well, I don't know what the best way to address homelessness is, to be honest with you. I mean, this is in some ways a political decision with respect to what aid people get and so on. And that aid can be financial ones for the people who have difficulty affording things. There can be social programs with respect to housing and housing vouchers. There can be improvements with respect to mental health care, to drug addiction, that are all the kinds of things that lead to homelessness. So I'm not sure what we can do to cure homelessness or solve homelessness as a court. But I can certainly tell you that as a judge, we see how homelessness exacerbates these problems. So often people who have drug addiction problems also have homelessness problems. And one of the key things in getting people right about their drug addiction is to be able to find homes for them. And so we've tried to have mental health programs and drug court programs that tie it into some housing programs, because if they don't have a house, they don't have a place to live, it's just an enormous problem to try to get them straight off of drugs. And if they can get sober, they can get employment. And if they can get employment, they can get out of homelessness very frequently. So as I say, I'm not sure what we can do to cure homelessness, but I can tell you that there's a tremendous factor in creating criminal behaviors that bind people into court. And we have to sort of spot those folks as best we can and try to get them into treatment type programs when they come in contact with the criminal justice system.
Thank you. Mr. Hornstein, what about the impacts of criminalizing homelessness on the court system?
Absolutely. I think this is a good example of a systemic challenge, of an issue, a very complicated issue that the courts and law enforcement are asked to solve. And maybe the courts and law enforcement aren't always the best entities to solve these problems. As people come into our courts, a lot of times it's at the end, the problem is already, the challenges, the criminal behavior, all these activities have already happened, and the judges and law enforcement and others, court system, are asked to address it then. So it's really, I think with most of these issues, it's about addressing kind of root cause, making sure as judges and as the judicial system officers are out there and administrators are talking about the impact of homelessness on the system, the cost, the impact of people's lives, and doing anything possible to encourage our county and our state and local leadership to make investments where to prevent these issues from developing. I think housing instability is certainly one of those challenges that have gotten a lot of attention now during COVID-19 as people face income challenges to their income or loss of jobs or salary reductions. So anything that can be done at the front end to address some of these issues before someone is homeless is really, really important. And that's where I think also the courts, by making sure the process around evictions is fair and is procedurally fair is very important. And also making sure that alternative courts like the drug courts and other treatment courts are plentiful and available for people who need it, so we can address some of these root issues and avoid the problem altogether.
Thank you. The next question sort of follows up on this. What measures should be taken to address the likely influx of eviction cases when the eviction moratorium ends? Mr. Hornstein.
Sure, absolutely. And I think those of us who are followed the what's going on around COVID-19 and the issues with that, with the moratoriums, it certainly will create a bottleneck at a minimum. And these are challenges, and people need these disputes to be resolved quickly. And that's where I think COVID-19 is forcing courts, both locally and around our state and around our country, to innovate quickly, and to which often courts are not known for. But I think it's about being comfortable as judges and being comfortable as a system by trying to do even more to reach people where they are, whether that's kiosks and remote dispute resolution, online, more work with using Zoom like this to address disputes and hear legal matters. The more we can do to connect with people and meet them where they are instead of forcing them to take time off work or come into Tacoma to the courthouse, I think the better off everyone will be. So, and that will also allow us, I think, to move more cases and more issues through the system faster. And that's certainly, I think, what parties on both sides certainly want in an eviction matter. They want it resolved. So that's very important. I think using technology, I've actually built a technology company before, so I have experience with technology and kind of modern cloud-based technology. So I just have that awareness, and that's something I certainly would want to bring to our court system and do everything we can to innovate on the technological side to make cases and make the proceedings more efficient. And I think that will do a big part, that will play a big role in us addressing this issue.
Thank you, Mr. Shishkoff. What measures should be taken to address the likely influx of eviction cases when the eviction moratorium ends?
I'm not sure that what Mr. Hornstein was just talking about has much to do with that specifically. It is certainly true that we're using Zoom already, and I've been conducting trials using Zoom for months now, nearly daily. We do still have some cases in the courtroom. One of the proposals with respect to this, one of the things I'm understanding is going to happen, in fact, is that the parties, the landlord and the tenant, are going to be asked to be diverted into a kind of an arbitration process. I think if you think about it, landlords don't want to remove tenants. They want to get paid. And if they don't have tenants, they don't get paid. But they want their tenants to get paid. One of the tragic things of this coronavirus process has been that so many people who played by the rules, who had jobs and so on, people in the restaurant industry, the travel industry and so on, lost their jobs through no fault of their own. And now they can't pay their bills. Well, there has to be a process by which this happens so the landlord can pay their mortgage and pay their bills and so on too. And so I really applaud this effort to try to, before any court action gets taken, that they be stirred into an effort to arbitrate the matter so they can maybe get back on track and everybody can be, and everybody can get satisfied. We don't want people thrown out on the street. We want them to have their safe housing. At the same time, we need to know that contractual arrangements are being enforced. This is a good way to do it. And I think we're going to be able to, that'll be one way to reduce the burden of lots of people coming in at one time, because I think a lot of them will be diverted and they'll solve their problems. Most cases are resolved by an agreement of the parties. This is a really good opportunity to get folks together to do that.
Thank you. The next question. There are community members who are living in poverty who owe thousands of dollars in legal fines. The inability to pay those fines impedes their ability to get a driver's license, a vehicle, a job, or housing. Over time, interest and penalties add up and debt may be turned over to aggressive collection agencies. What do you propose for fines to be paid off or consequences rendered in a reasonable way that does not create more barriers to employment and greater inequity in punishment for those living in poverty? Mr. Shishkoff.
Well, one of the things I was kind of excited about, and I thought maybe it was going to get off the ground a couple of years ago, but the legislature didn't pick this up, and it was supported by the Attorney General's Office of the state of Washington, as well as the folks at the Office of Civil Legal Aid. And that was a proposal whereby which there'd be a central registry so that things like traffic tickets could be paid in a place in one spot. So for instance, if you get a traffic ticket in Ellensburg and you have another one in Vancouver, Washington, and you need to go to various courts to pay these things off. You can mail these things in, but what happens is when people are late in doing this, a warrant gets issued and more fines get added to it and so on. And there's no good way to do this. You have to take off time off work, you get your license suspended, you can't keep your job. And so it becomes a really difficult deal. And so a central registry by which a payment process could be established by which these folks can pay off their fines over a period of time and meanwhile get their licenses reestablished, I thought had a great deal to recommend it. And why it hasn't been more aggressively picked up by folks in the legislature, I don't know. But with respect to legal fines and legal financial obligations that we impose, we have gone through a process by which we've forgiven a bunch of those. And of course, recent court decisions have strictly limited when those can be imposed, and only in situations where people are not indigent. The indigent can only be assessed for essentially restitution and for crime victim penalty assessments.
Thank you. Mr. Horenstein.
Sure, absolutely. And I think a lot of progress has been made in this area. And a few years ago, the legislature actually enacted LFO reform, or legal financial obligation reform, with House Bill 1783. When I was at the state courts, I was really proud at that time that when I was legislative director, that the Chief Justice, Mary Fairhurst, and also the state court administrator, Kelly Dietz at the time, actually for the first time supported that legislation and supported that effort. So the legislature has made a lot of improvements. The Supreme Court has issued a number of cases, as the judge mentioned, making sure that courts are only imposing these fines when people can actually afford to pay them. And that's, I think, kind of an accounting principle as well. And we do deal with this in some contexts at the Department of Social and Health Services and child support, where I work currently, is that it doesn't make sense to assess a bunch of fines and fees that people will never pay. It just puts these huge numbers on the balance sheet, and then it never gets paid, and it creates barriers and problems for individuals. So we need to always be looking at that and looking to improve that and making sure we're only imposing fines when people can actually afford to pay them. Otherwise, it's just limiting people's ability to return to society and be contributing members. And I don't think anybody wants that. It doesn't make good sense. And then, like the judge mentioned, the issues with the license. I know there's a pending case I think a lot of us have read about, with the ACLU actually suing the Department of Licensing. And I worked at the Department of Licensing, so I'm very familiar with the criminalization, especially around driving, that happens when people don't pay tickets. But fundamentally, it's about creating a system. I think that goes back to my prior point about making the system accessible and make it more customer service friendly. I think a lot of people get into minor legal trouble and they're so overwhelmed by the system and the process that they don't come to court to resolve it, which then the problem cascades. So we need to address that.
Thank you. Next question. Is it appropriate to impose more restrictions on what cases go to trial? For example, is there a need for more mandatory mediation and settlement efforts? Mr. Horenstein.
Well, I think people fundamentally have a right to take a case to trial. I don't want to limit that, but there are just some realities, right? The more cases we have that go through the traditional adversarial process, the longer it takes for everyone's cases to get through. And the courts are often prioritizing certain types of cases, criminal matters and other certain civil matters, to make sure that certain cases can actually get resolved quickly. So that will continue to be an issue unless the legislature and local government just waves a magic wand and massively increases funding to our courts. But on the other side, I do think judges and everyone in the system should be encouraging alternative dispute resolution. I think the court, those of us who have gone through trials, or those of us who have witnessed trials, or and followed what happens in courts, usually the outcome of a trial is people end up spending, especially in the civil side, spend a lot of money and not often too happy at the end. It's just one of these challenging processes that's not ideal for everyone in a number of cases. So the more we can encourage people to resolve their disputes through a mediation or arbitration, the better. I definitely support efforts to require people to try that first in as many cases as possible, because I think that in the end serves everyone better if we can get these cases settled instead of going to trial, which is just a challenge for the systems, challenge for everyone.
Thank you. Mr. Cheshkov.
Well, there's a lot of things we do already. The mandatory arbitration rules and the amounts of money involved with that. You can have mandatory arbitration in civil cases in which the amount of damages is $100,000 or less. A couple of years ago, that was $50,000. And so the legislature authorized that to be increased if each of the individual courts could then approve that or not. And Pierce County did pretty readily approve the increase in the cap from $50,000 to $100,000. So a lot of personal injury cases where the amounts of money involved are less than that go there. We find it's been difficult to do mandatory arbitration with respect to, or not mandatory, but at least settlement conferences with respect to family law matters. There's a number of reasons for this. One is there simply isn't the resources to have somebody act to do that. There are a number of folks that do act as private mediators, and they do charge money, and we certainly encourage folks to do that. But a lot of the folks that we have are simply don't have the money. They just don't have the money, and so it makes it very difficult to do that. Moreover, some of the issues with respect to family law, for instance, are very intractable. If somebody says that this person is bad with my child and it's going to cause the child problems, there's really kind of not a whole lot of settlement that's going to do that. Finally, they're going to have to see a judge and see what the truth is about what the situation is. the vast majority of cases are settled nonetheless, despite these things. And certainly anything we can do to encourage that is good. And we've embraced those opportunities to do that when we can.
Thank you. Next question. What have you seen as the most effective form of treatment for deterring juveniles from further criminal acts as juveniles or as adults? Mr. Chisholm.
Well, I have to say that we have found that careful watching is useful. And so our juvenile court has received a number of a lot of national recognition, because one of the things we've done is sort of intensive watching, if you will. We use social workers or whatever. We have regular check-ins and so on. We try to make sure that people are able to know when they're supposed to have a hearing, that can participate, and we send constant reminders and so on. We've tried to keep juveniles out of custody as much as possible. That isn't always possible, but as much as possible, because we find that by putting them in custody, it only in some ways makes them harder criminals and gets them associating with people who are more hardened criminals. So none of those things of, the kind of the lock them up kind of stuff doesn't work. The watching carefully thing to some extent is about the maturity of these folks. To some extent, some people don't grow up until their 30s, but a lot of kids are going through a crisis in their teens. And if we can just kind of hold their hands through a lot of this stuff with things that are directed towards whatever problem they have, one of the things they really need is leadership. With so many kids that are coming from homes with single parent families, they need some kind of leadership to get them directed towards appropriate social activities and so on. So to the extent we can watch them and do that, we can sort of get them through those days of difficulty that they have in their maturing process. And because in the end, the vast majority of these folks turn out to be, again, law-abiding, tax-paying citizens, when they grow up. Not all of them, sadly, but most of them.
Thank you. Mr. Horenstein.
Thank you. Well, again, I think this is one of those issues where the court system and our juvenile court system is asked to resolve a lot of things that it's not, the best way to do it or the best equipped to do it. And to address, we talked about trauma and trauma-informed kind of decision-making in courts, but this is one of those issues. I think for juveniles and children, just because of their brain development and the growing research that we have around juveniles and children certainly can face trauma. They're traumatized by being in jail and by the traditional criminal justice system. So there are certainly cases where the traditional system makes sense, extremely violent, murders in these extreme examples. But for a number of cases, the juvenile justice system and the criminal justice system is not the place for children. So I think we need to, as judges, be out in the community. Judges and other leaders in our community need to be out, again, as I talked about, working at the front end and raising awareness about these issues and how they play out in our court system, and why the court system and even our juvenile court system is not the best way to meet the needs of these children facing challenges, often challenges at school, challenges at home, challenges in the community, all sorts of root issues that need to be addressed. And so by continuing to beat that message and to share that message, we can continue to raise awareness about new approaches and new ways to address these needs in the community without just taxing the juvenile justice and the criminal justice system, and then hoping it all works out well. So that's what I would strive for and would encourage others to do.
Okay, thank you. Last question. What are the advantages of alternative sentencing, and how would you use alternative sentencing in cases that you adjudicate? Mr. Horenstein.
Sure. I think, in a lot of cases where individuals have committed a crime, or either it's drug offenses, other offenses that, they're certainly not all victimless, but they certainly have where just putting someone in prison for a number of years is not going, or for a chunk of time, or jail for a chunk of time, is not necessarily good for the individual, and is certainly not good for the community, because of the costs and the results, are just not there. It just doesn't justify it. So I think alternative sentencing, alternative solutions, particularly around when there are mental health issues and drug cases, is kind of one of our success stories as court systems around the country, and Pierce County as well. Continuing to double down on those programs and those efforts, I think, serves everyone well. The goal is to rehabilitate most of these individuals, get them back functioning in society. A lot of them have families, children, and partners to support. And so the more we can get people through a system, get them treatment, hold them accountable in some way, certainly, but get them back functioning in society, I think the better off we'll be. And it's certainly more efficient it's certainly a more cost effective in the long term to do it that way. And so I firmly believe in that. I firmly, would love as a judge to learn even more about it and be, be a leader on how we continue to develop these programs. And I'm really excited. When I worked at the courts, I was excited to learn about these programs and advocate for these programs. They get a lot of public support and a lot of, and they make good sense, good policy.
Thank you. Mr. Shushkoff.
Yeah, we're lucky in Pierce County in that Pierce County's drug court was one of the very first in the United States in the early 1990s. I think we were like the 8th one created in the United States. And the idea of drug court is that if we can get folks treated, that if we can get them sober and we can get them treated, and if you will cure their addiction, and that's not an easy thing to do, then their reasons for resorting to crime, to get money, to support their drug habit, but not just that. A lot of these folks don't have any money for, going back to things like homelessness. They've lost their job. They can't maintain employment. They can't get to work on time because they're using drugs, because they have other mental health conditions that make it difficult for them to get off drugs. I mean, one of the things we find is, and this is a very complicated thing, and what it makes it more difficult, is a lot of these we have co-occurring problems. Somebody has an anxiety problem that's maybe clinically elevated anxiety issues or depression issues, and they use drugs to feel better about themselves, to feel better so they feel like they can function. The problem is that's a short-term thing, and in the end, it causes them a great deal of destruction. So they can't maintain employment. They steal to get money to pay for their car, to pay for their housing, to pay for food. And what we're trying to do is stop that. We're trying to break this cycle so that they can get back to work, so they don't have to steal, they don't have to do these things. And we found that we can save $8 or $10 to one that we put into treatment facilities in the amount of crime and property damage we save victims of crime otherwise, because we take somebody out of that system. And it doesn't work simply, but it does work.
Thank you. Now it's time for closing statements. And I'm sorry to the audience members that we didn't get to all of your questions. Each candidate has 1 minute for their closing statement, and we'll change the order of the opening statements. So we'll start with Brian Shushkoff.
Well, I was born in Tacoma, and I grew up here, went to public schools here. After law school, I opened an office in Tacoma in the South End. I practiced law for 19 years. I represented people of every social, cultural, and racial background in a wide variety of cases. And in 1996, I was elected judge. I served on the court's executive committee for 11 years, and in 10 of those years, I was either the presiding judge or the assisting presiding judge. I was the presiding judge for 4 years, which is longer than anybody that's served in that capacity in the last 40 or 50 years. In that time, I've tried all kinds of cases that are of significant moment to our community. One of the things I kind of regret, and it's always difficult in a forum like this, is to talk about the actual courtroom work, because that is the vast bulk of what we actually do. And not everybody is good at this. Not every lawyer can walk in and knows how to get an exhibit admitted, does not know how to pick a jury, does not know how to do all those things. And it comes through years of experience. I suppose that's why they call it the practice of law. I've done this very well and very successfully in private practice. I was involved in several major homicide cases, which I was able to win. And the great nice thing about that is when I ran, the homicide detectives I beat in those cases endorsed me for judge. So, because they knew I'd do a good job, and I can do a good job still. Thank you.
Thank you. Mr. Horenstein.
Thank you again for the opportunity tonight. It's been a great discussion. And I think now more than ever, people are crying out for change. Those of you at home watching, you know that society is changing, and not all of it, makes you feel comfortable, but change is hard. But certainly I think there are 22 judges in Superior Court in Pierce County. And I think it's fair to change it up a little bit from time to time and recognize that for us to have a robust system, a system that works well, it makes sense to shake things up. And I offer an alternative, and for the number of years that I've been practicing, I've been an attorney, I've worked for state agencies, I've been a small business owner and a public servant. So I've developed a lot of experience through all these different positions and work that I've done. So I believe confidently, as working for the state courts and working with judges all across the state, I'm ready to be a judge. I have the capacity to be a good judge, and I would love the opportunity to be a judge and work for you and work for this community. So thank you again for the opportunity. It's been great to be here.
Thank you both. Brady J. Horenstein and Brian Shushkoff are the candidates for Pierce County Superior Court Department 4. You should have received your ballot. I know I got mine on Friday. You should have received it by already, and you should vote no later than November 3rd. I would like to thank our timekeeper, Terry Baker, Tacoma-Pierce County League of Women Voters, and our community sponsors, the American Association of University Women, Centro Latino, East Side Neighborhood Advisory Council of Tacoma, the NAACP, St. Leo Church, Summit Waller Community Association, Tacoma-Pierce County Affordable Housing Consortium, Tacoma South End Neighborhood Council, Tacoma Urban League, UW-Tacoma School of Interdisciplinary Arts and Sciences, and the YWCA of Pierce County. You can see this and other League of Women Voters candidate forums at our website, www.tacomapiercelwv.org/2020elections.html. Make sure to read your voters pamphlet. Look at Vote 411, that's vote411.org, where you can find answers to your questions that are posed to all the candidates running for office. Read the candidates' websites and do everything that you can to be an educated voter. And please do not forget to vote by November 3rd. Thank you, everyone, and have a good evening. Bye-bye.
Thank you.